Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today we're going to be talking about divorce and family law with questions that have come in from our viewers over the recent months. Joining me today, as always, is my co-host Jesse Barrientos. Jesse, how you doing today?
Very good, Dave. How about yourself?
Good. Good to see you, Jesse. There's a lot in the news with divorce and family law. I don't know if we're going to get to this show, but there's a Supreme Court hearing going on right now about the constitutionality of the Defense of Marriage Act, and there's also gay marriage that's going on in front of the court. So we're anticipating a decision sometime in June. But anyway, let's get right into the people that are having issues right now.
Sure.
And who've been writing to us. Let's start with Kevin. He lives in Stager, Illinois, which is Cook County. Keep that in mind. He's considering fighting for custody. What is this best interest of the child standard that he keeps hearing about from his lawyer and from the judge?
Well, a lot depends upon the specifics of his situation. For example, is this post-decree?
Pre-decree. So they're not divorced yet.
So pre-decree, so they're going through the process. Right.
And custody is being addressed right away from the judge. Because once the judge knew there wasn't an agreement on custody, she sent them to mediation. Yep. And now they've come back from mediation without a resolution.
Right.
And the judge wants to move this case forward. So she's appointed a guardian ad litem, and they're going forward. So he's hearing about this standard. What should he expect?
Well, what he can expect is that custody battles are very often extremely expensive, extremely taxing, emotionally and physically, and not just for the litigants, but also for the children as well. People don't think that it has an impact on the children, but it very often does. And so they will appoint a guardian ad litem, which is an attorney. It's not really the child's attorney. They have a child rep, which is different, an attorney for the child, and they have all different variables in terms of what those specific appointments mean. But a guardian ad litem is someone who is going to do an investigation and is going to report back to the court in terms of what they believe is in the best interest of those children. Now, there are other things that they can do too, and again, this is where cost prohibitions come in. There's what they call, under Section 604B, which is a custody evaluation by a psychologist, by an expert. And so that is probably going to set somebody back $6 to $10 grand or so, depending upon who that is, and that's just for the evaluation. It's going to take several months, probably 3 to 6 months or so, depending upon what it is. And I've been involved in cases that have had guardian ad litem and 604B, and actually 604.5. But what they're looking at is what is best for the child in terms of where they're located, what's going to be better for them in terms of their psyche and everything else, and how they're going to be able to weather the storm.
Who appoints the guardian ad litem, and how is that guardian ad litem paid?
The guardian ad litem is paid by the parties, or sometimes the court will appoint legal aid guardian from them to do it. A lot of times people who are on the guardian ad litem list, they have an obligation to do at least one pro bono case a year. But the judges know, and they don't tax the same people for that all of the time. But in an appropriate case, a judge will do that. Some judges prefer guardian ad litem, some judges prefer the 604B evaluator. It just depends on the specific case. But again, people just kind of don't get it. A lot of times people have different reasons for wanting to get custody. One reason might actually be that they believe that's the best interest of the child. Another one might be because, hey, they don't want to pay child support, or they want to receive child support. It's a horrible, horrible business out there. People use kids to hurt the other spouse.
Yeah, I think if you took away the monetary aspect of who has custody, you'd have a whole different scenario on how custody was decided and who wants to fight for it. Because a lot of the people that I meet with over the years, and I'm speaking specifically of men usually,
right,
who are working full-time jobs, who have the inkling for custody. If they really thought about what would be involved in having full custody of the child, they might think twice, because I don't think they realize the commitment that it's going to take versus a stay-at-home mom, for example.
Absolutely.
Who has the ability to dedicate all of her time, or his time if he's a stay-at-home dad, towards the child. The working spouse, there's not a whole lot of opportunity there to really get so far involved in the child's life, at least not from what I can see, because you have to work. You have to you got to put food on the table.
Absolutely, you have to work, and if the other person is in a position where they could spend more time with the child. But when you talk about kids that are school age, that's a little bit different as well. I'm a Gardner ad litem in DuPage and also a mediator, and we have people that come in for mediations a lot, and they're stuck on those kind of things. We always start with just kind of telling people, okay, you know, whether or not they understand that everything is in the best interest of the child and whether or not they'd be willing to give up their conveniences for the sake. And they always say yes until it comes to, oh, well, I've got to drive the way out there to pick them up and then drop them off. Well, wait a minute. We just talked about you saying that you would do anything that's in your child's best interest, even if it inconveniences you. And so realistically, at some point, there's a lot of folks that really just don't want to be inconvenienced.
Well, what about a duplex with an adjoining door in between?
Well, that might be ideal for like a joint residential custody situation. But I guess to kind of wrap up on Kevin's question, the best interest, there's a lot of factors that go into it. And, it just really depends on the specific situation.
But if you can work it out amongst yourselves, that's always the best advice.
It's always
correct?
better to be able to work out an agreement amongst yourself. Otherwise, you're going to have other people that don't know you and that are going to have just a limited amount of time, a thumbnail sketch of your life to make a decision.
Don't know you and really don't care about you.
Well, I don't know if they don't care about you, but certainly don't know you and can't get to know you in that little bit of time they're going to spend with you. And that's not their job. Their job is to make a determination and to move on to the next case.
Okay.
All right, Dave, we have Christina in Midlothian. She asks, how do I know if my case is going to be contested or not?
Well,
that's a good intro from the other.
Yeah, that's the very first question that we want to know when we meet a prospective client. You have to find out whether or not the parties are going to agree on all of the issues pertaining to the divorce. So if they agree on getting a divorce, but they can't agree on custody, support, visitation, division of property, allocation of debt, then you don't have an uncontested case. So everything needs to be in total agreement to the point where both parties will sign off on documents. The proposed judgment could be presented to the court, and the court could sign off on it if it's not unconscionable. If there's one issue holding it up, and that might even be a piece of property, it might be the domestic animal, it could be division of retirement. If any item is holding it up, you have a contest. Granted, not a full contest like you'd have in a custody battle.
Right.
But even how to divide a car, retirement, miscellaneous property, that's going to cause a delay in the case to the point where you're going to have multiple attorneys involved, you're going to have discovery, you're going to have full-blown hearings, and it really is silly. If you're so close, try and work out that last detail because you'll save yourself time, energy, money if you can keep the case uncontested. Or agreed upon, as we say. It's another word for uncontested is agreed upon.
There's a lot of to do about people just they don't get it. They would rather spend the money that you're talking about than resolve it because they just don't care for their spouse that much. And then we always tell people that come in terms of the financial feasibility of what they're doing. So in other words, look, I've had people that fought over the little solar yard lamps that go out there that cost, I don't know, I guess you can pick them up for $35 or $40, something like that. And so, realistically, just the conversation, all right, they could have bought a new one, and they just don't want the other person to have something that they want, and that's what sparks a lot of that.
Right. Those actually fail in the Chicago winter, I think. I don't think those things survive the winter.
I don't know.
But a lot of the reasons, though, why something would not be agreed upon is not that the parties don't want the divorce. They don't want the other party necessarily to move on. Somebody might have a girlfriend or a boyfriend now. Someone is hurt. There might be adultery. There might be dissipation where someone is using marital funds to do non-marital purposes. So a lot of times one party just doesn't want to let the other go. It's not always both parties want the divorce. Sometimes one wants it, one doesn't.
It's true.
And I've got a friend in Texas that always says, he's never going to get a divorce. He's never going to let that happen. And I say, look, you're only one side of this deal.
Right.
Okay, you can control what you're going to do. But you can't control that the next day your spouse is going to wake up and say, I want to move on. Right. I'm not happy in this relationship. I want to have more freedom. I want to have more excitement. I want to do this, that, and the other. So it takes two to tango, but it doesn't necessarily take two to divorce. It takes two to have an uncontested.
Right.
But it only takes one to start a contested case which could drag on for years depending on which county and depending on which attorney you hire.
True enough, and coming on the heels off of that too, in terms of doing kind of what you want, thinking they're not going to get divorced. People, even if there are no issues, there's only two ways to do it. Either you're in agreement, or you're not. And if you're not in agreement, then it's a trial. Even though there have been cases that just should have been settled, the other side was just not wanting to agree for whatever. Maybe it's for one of the reasons that you talked about. And so you feel badly and tell them, well, there's really nothing here to fight about, but since they're not agreeing, there's only one choice then, and that's to set it for trial and then let the judge take care of it. And unfortunately, that happens quite often.
And then for those that love to litigate, they'll take it to a trial, and then they'll appeal the decision. Even though the marriage is over, there's some issue, whether it's division of property, allocation of debt, something that they didn't agree with at the lower court, that they want to appeal it. And sometimes they don't get a fair shake at the lower court.
That's true.
Now, I'm not going to say everything goes perfect in court, and that's why we have appellate courts. But some people just like to prolong the litigation without any decency or sense as to what they're really doing.
Well, hopefully those folks have some money, because it costs money to litigate and certainly to do the appeal as well.
All right. Well, a lot of times they don't pay their attorney.
That's
and the
true
attorney
enough.
withdraws, or they file bankruptcy, or
Go
or they
through other
just-
attorneys, right.
Yeah. Let's talk about Karen in Orland Park, Jesse. She has a court-appointed guardian ad litem that we just spoke of. She wants to know, why does she need to have a guardian ad litem for her child, and why should she have to pay for it? I guess the court is ordering her to pay for it because she's the breadwinner and the other spouse doesn't have the ability to pay.
The long and the short of it is because the judge said so. If there's a custody dispute and mediation has failed, then there's no other real alternative than to appoint a guardian ad litem or to do what we were talking about before, 604B evaluation, which is a custody evaluation, which costs a lot of money. And so the court wants some guidance. The guardian ad litem really is the court's kind of right hand in terms of finding out what's in the child's best interest. The court has many, many cases on its docket, and they can't make the investigation on their own. And so they're relying on the guardian ad litem to do his or her job in order to report back to the court to give them some guidance as to where they're going. Now, the judge doesn't have to follow the recommendations of the guardian ad litem. He could make any decision he wants, but at least there's been some investigation. But the reason why she has to pay for it is because, again, she's the breadwinner. If you're in a marriage, and it depends, if it's a 1 or 2 year marriage or a 30-year marriage, it makes a difference. And one party has been primarily the breadwinner. The other person is not in a position to be able to go out right now and to get a job, or doesn't have marketable skills to be employed, and that happens really a lot. The person has the money, and it's a matter of the playing field. So to level the playing field, because you can't just say, okay, well, guess what, Dave, I have all the money, and so we'll litigate it, and you don't have any money to pay anybody. Not going to be so. The courts are going to even that up.
Well, in Karen's case, she wants to know if the court should have taken into consideration the financial condition of the parties, because supposedly she's not in a great financial position. It's just her spouse has no financial position. So this is a struggle for her to make ends meet and her obligations towards her child and pay the guardian ad litem. So she wants to know, does the court take that into consideration, or does the court just say, hey, I want a guardian ad litem appointed?
No, the court certainly will take that into consideration, because obviously the guardian ad litem has to be paid, and generally it's by both parties. But if one is the only party that's working and the court thinks that it's necessary to do it, then absolutely it's just the only other alternative is for her to, hey, guys, come to an agreement.
Yeah, and how did that guardian get appointed, she wants to know too. Did the judge know that guardian? Is there a list that they go off of?
There's generally a list, and guardian ad litems have to go through a certain amount of training, and a lot of times judges will continue to use the same people because they're familiar with their work, and they know that those particular people do a good job. And so the guardian ad litem can be appointed by the court on its own motion, or either party can move to appoint a guardian. The attorneys can agree to a specific guardian, or if they can't, then again, the judge can just appoint whomever.
And it seems like in her case, the guardian is having a lot of involvement in the case. Is that typical, or do some guardians almost take a step back and just do a minimum?
Well, I mean, I suppose it's like there are different people who do different kinds of jobs and all that, but the guardian ad litem's job is to do that investigation, to do their due diligence, and to make that report back to the court, because they want to make sure. And a lot of it involves not only talking to the children by themselves in either party's home to make sure that it's fair, because children do act differently when they're with different people. Also to talk to the parents.
Is there anything that's out of bounds or off limits? Can the guardian get into sexual misconduct allegations and things of that nature?
Well, if those allegations are made, then the guardian ad litem probably would bring a motion and bring it to the court's attention for some guidance on where the court wants to go on that. It just depends on what it is. I mean, if it's an emergency type of situation, then of course, a DCFS can become involved, or the police. It just depends on what happens.
Yeah, that would be a blessing if they got involved.
Yeah, not so much.
Oh,
yeah.
Okay. What do you have for me?
So, we have James in Naperville. He asks, what is the average length of a contested case with no children?
Okay. Well, with no children, you've kind of cut out major issues. Now, that doesn't necessarily mean you're going to be any quicker to the finish line, because there are tactics that one could do to stall. But I would say on average, and this varies county to county, attorney to attorney, case by case, but in a contested case, you could be looking anywhere from a year to 3 years, depending on, it's a wide range there, I know, but there's cases that go to full discovery. They take depositions. They go to hearings on all kinds of minutia up and through the trial. And there's other cases where even if custody is in dispute, they're not trying to drag it out. They're trying to get a quicker resolution.
Right, but in this case, there's no custody issue.
There's no custody, but there's still property. There's allocation of debt.
If there's more property, the more property there is, the more litigious, perhaps.
Right, and there's also the issue of maintenance. So let's say there's no children, but one spouse was a breadwinner and one was not, and they had a long-term marriage, and they can't agree on how much spousal support the other should be entitled to, if any, and for how long. The maintenance statute talks about many different factors that the court has to consider. It's anything but cut and dry. There is no percentage guideline to go off of. There's several main factors, but in a case where maintenance is at issue, you could be looking at a long time before a case settles, and there could be even an interlocutory appeal, which is an appeal within the case of a final order.
Before the case is done.
Before it's done.
Tell the folks at home what maintenance is.
Well, maintenance is spousal support. One for the other, and it's based on a number of different factors: length of the marriage, lifestyle that the parties grew accustomed to, disparity in income, and a host of other factors that the court can consider in terms of how long to give maintenance. There's maintenance that can terminate, there's maintenance that can be permanent, there's maintenance in gross, which is for a certain dollar amount, which can be paid off quicker. There's reviewable maintenance, where the party can come into court after a certain number of years or months and say, I still need maintenance, or I don't need maintenance anymore on the other side.
I don't think, have you ever heard anybody say they come into court and say they don't need maintenance anymore, Dave?
No, but there's statutory provisions.
Right.
There's people who went and got remarried and foregone the maintenance. There's people who
Well, if they do that,
cohabitated with someone on a resident conjugal basis, which is foregoing maintenance. And then, of course, the death of either party will stop maintenance, obviously. So, maintenance is a very, very contested issue. I would say secondly contested behind custody, maintenance.
What's the quickest? Because he asks the average length of a contested case without any children.
Well, a case can start out contested and then turn uncontested once a couple issues are resolved. So
that's what happens very often.
3 to 6 months you could be done, even in a contested case, if the parties are reasonable, the attorneys are reasonable, and of course the court has to be accessible. Some courts you can get a quicker final date, and some you have to wait.
Right. Sometimes a lot of times do a pre-conference if if the parties are just stuck on an issue or two, or on the issue of maintenance, or whatever the case may be. The parties will do a pretrial memorandum that kind of lays out everything, lays out the length of the marriage, the children, the specific issues, all those kind of things, what their proposal is on the issues are not agreed upon, and all that, and the judge will give his or her guidance and recommendations. Now, the parties are not bound by those, but at least you have an idea where the judge is going to go on that. And unless the evidence at trial is diametrically opposed or different to what that is, then what's going to happen? what's going to happen is you're going to get the same decision. And sometimes the judge would get, may get irritated. There's a lot of things that you can talk about back in that pretrial conference that you might not be able to get in an evidentiary hearing.
Yeah, the only exception is in Cook County. If you get a calendar judge, that won't actually be the judge that's hearing your trial if it goes to trial. So with the exception of Cook County, you're pretty much going to have the same judge throughout the case. In some of Cook County, you have the same judge even at post-decree. But you mentioned pretrial, and I think it's important for the viewers to understand that it's not a formal hearing.
Right.
That a pretrial is very relaxed. Can you go into some of the mechanics of it? I mean, some are in the judge's chambers just kicking back.
That's generally what happens, but again, the judge does have the pretrial memorandum that generally typically does not get filed. It just gets served on the parties and also the judge, so they have a chance to look at it. And
I've done pretrials where the other side didn't even have that prepared. They were absolutely unprepared.
You see
didn't put any time in the pretrial, and it was a waste of the court's time.
Right. You see that a lot. But again, just there are people who have different work ethics, or perhaps it was miscalendared, or it could be a whole host of other kind of things. But in order to get the maximum benefit out of a pretrial, really both parties need to be prepared. But it does. Generally, it's just the attorneys and the judge. And again, there's no court reporter. There's no anything.
And interestingly, the clients don't have a say in it. They're not even present.
They're not even present, and there's a reason. There's a good reason for that, because the judge is trying to give his recommendations, and sometimes, honestly, there are things that go on in a pretrial, that you say and that you represent to the judge, and you advocate your client's position. That hey, the parties don't understand. They don't have the grasp of kind of the legal mechanics behind it.
Yeah, we're also talking about a judge that has a full caseload.
Yes.
May or may not be that involved in the case. And you're asking that judge to read the pretrial memos, get involved in the discussion, and come back with some sort of recommendation. So you're really putting a lot on the judge in a pretrial. A lot of people don't realize that. They don't take it seriously, but you're really putting a lot on this judge, and a lot of what the judge says is pretty much what he or she is thinking. So you want to relay that back to your client to let the client know where the judge stands and what they're recommending. And it sometimes can facilitate a settlement.
Right.
Because if you know the judge is totally against maintenance and you're going to be having the trial in front of that judge, you might as well give up the issue of maintenance, right?
Well, or if he or she has told you pretty much that that's what they're gonna what their recommendation would be, then again, unless there's something that you didn't tell them back in the pretrial that's drastically different or diametrically opposed to what that is, then that's probably what the decision's going to be after a full-blown hearing.
Okay. Terry in Joliet, Jesse, is asking, he has visitation under his judgment for dissolution, but visitation has gotten difficult. In other words, he's not getting the visitation that he once got pursuant to the judgment, and he wants to know what recourse does he have against his ex.
Well, in order to enforce an order of a court, generally what happens is the party would, file what they call a petition for rule to show cause, and basically show cause why the other party isn't following the court's order. You see that sometimes with child support issues where somebody hasn't paid support, and they could have a legitimate reason or not. It just depends. It's important for the folks at home to understand too that what they need to do is, the clock doesn't stop running unless you file that petition again for support or to increase or to decrease until the filing date. So it's important to be active, not just wait and let it go on. It's important to go on to take care of that. But you file a petition for rule, and the other person will have an opportunity to appear and to respond to that. And depending upon which county you're in, the burden will shift. Generally, if somebody brings a motion, it's their burden to prove. But in a petition for rule, once a rule order is issued, and generally it's issued upon a verified petition for good cause shown, and they'll issue the rule order, and it's generally personally served on the other party. Then the burden shifts for the other party to come in and show cause why he shouldn't or she shouldn't be held in contempt. And they look at things whether or not it's willful. Oh, perhaps he didn't get visitation because she just wanted to punish him, and that is what came out in court. Then she, most likely would be held accountable. Additionally, she bears the cost of his attorney's fees if it's willful contempt or without justification.
Well, in Terry's case, the spouse is alleging that Terry is not exercising visitation often enough or consistent enough. Therefore, she's kind of withholding it when she wants to.
That's not going to work. The proper thing to do in a situation on her side would be to file a motion to modify visitation.
So maybe reduce the frequency or
Well, to
reduce
try,
the number of days?
Right, not just to unilaterally yank the kids. You know, it's very important for the kids to have both of their parents in their life.
Yeah, well, that's what's happening here. When Terry doesn't show up on occasion, the child is left kind of, in the lurch.
And that's true. And so, I mean, you can't, that's the other thing, you can't make somebody exercise visitation.
Yeah. Well, I think the thing to do, as you said, is maybe amend it by agreement.
Right.
Because whatever the agreement was and the judgment was originally, that visitation has changed to the point where maybe Terry can't do every other weekend or 2 nights during the week. So maybe they need to back it down for the benefit of the child.
But typically what happens is people feel like that they're losing something that they had. Well, if they're not exercising, they never really had it. And so, that might be kind of a roadblock to that kind of an agreement.
What about getting the police involved? That came up in his question as well, in terms of making a report that visitation is being withheld, and it could be...
There's a statute, and but, it just depends on where you're at. A lot of times the police don't like to interfere. Basically, it's called visitation interference, and it's like a citation. And if a person is found, is convicted of that, then, the criminal sanctions go up. But I find very often that the police just don't want to write those things. They'll make an information report, but very rarely write a citation. That's been my experience, though.
Okay. Can this issue also go back to mediation for the limited purpose post-decree of determining visitation scheduling?
It sure can. And mediation is a great tool because you have someone who's neutral, and actually required anyway. A lot of times, in order to bring a petition, not a petition for rule of show cause, but to modify, you have had to have tried to work it out on your own, and if not, then go on to mediation, because if you don't, that's where you're headed in any event.
Will the court appoint a guardian or a child rep again, or will they leave this post-decree to the parties?
They probably won't. It just depends on what it is. If it's just a visitation issue, it depends upon how severe it is. But probably, again, you're going to go to mediation.
Okay. In terms of attorney's fees, if someone's not getting visitation, they want to seek an attorney to bring the rule, what could they be looking at as a retainer and or final fee?
It all depends on the hourly rate charged by the attorney. It depends on the location. It depends on how much time is going to be involved. Retainers go all across the board. They go from $1,000, $1,500, $2,500. It just really depends on the attorney and the specific issue.
So this could be thousands of dollars to bring back a visitation issue.
To bring back visit, or even to enforce an order. It sure could be.
Okay, and who pays for that?
Well, initially, the person who's trying to enforce the order would pay for that. However, if the court finds that they've done it willfully, then what will happen is the other attorney will bring their fee petition, and generally, if provided it's reasonable, the court will approve it, and that person will have to pay because they didn't comply with the court's order.
But importantly, initially, the party bringing the motion has to bear their own expense.
Yes, right? Exactly.
Okay. Keep your questions coming at questions@legalactiontv.com, and we'll do our best to get them on the air. I'm David Siegel alongside Jesse Barrientos. You've been watching Legal Action. We'll see you next time. Take care.